whatever. He do not need an attorney.
City of Detroit versus Contrail Grigsby, case number SP 168333921, SP 1683393, counts 1 and counts 2. Appearance for the record, please.
And special appearance of Contrail Grigsby Jr., Shuri Juris and Proprio Persona.
That went over my head.
No rights. I do not waive no right, none of my rights.
All right, Woody is the date and time set for a pretrial. What do you want to do with these cases?
Should be taking it. First, I want to I have added 2 pieces of documents to the court. I want to put them on a record. And my affidavit of conditional acceptance and my Naturalization Act of 1779 I already had on the record. So
I want to take it. You don't see this phone? All right. What do you do? Okay, that's on record. What do you want to do with these cases?
I'm fighting.
All right, so you want a trial date?
Yes, sir.
I'm going to give you a jury trial date. Let a jury of his peers determine whether his innocence or guilt. Jury trial date, please. In person. The trial date will be in person.
Jury trial. Can handle this. Can this right be handled in private?
At this point, I would ask the court to allow me to withdraw. Mr. James did file a bar complaint against me. I feel at this point I have a conflict.
Mr. James, go ahead and activate your audio.
Yeah, I have no problem with that.
Well, I have a problem understanding what's going on. So you had previous counsel with SMH. You were then given conflict counsel with Mr. Smith. Are you planning to hire private counsel?
No, ma'am. I didn't ask him to withdraw.
Yourself?
No, ma'am. I didn't ask him to withdraw. He took it upon himself to do that. I have nothing to do with me.
Did you file a bar complaint against him?
Yes, I did.
Okay. And how do you think that's going to affect your working relationship with your attorney?
He needs to do his job. It was some things that you informed him to do that he did not do. For us getting the evidence for me to prove that I didn't commit this crime that you guys got me charged with. He was supposed to get in touch with Intoxalot. You told me that he don't have to get in touch with Intoxalot. I'm of the belief that's his duty to get in touch with Intoxalot to find out what's going on. And he haven't done his job.
Welcome back, everyone. Today's episode dives into 2 wildly different courtroom disasters that somehow share one thing in common: complete chaos. First, we head to Michigan, where a self-proclaimed sovereign citizen walks into Judge Perkins' courtroom armed with nothing but delusion and a stack of meaningless affidavits. He claims to be making a special appearance, whatever that means in his own legal universe, and the judge isn't having any of it. And just when you think it can't get worse, our second case introduces Henry James, a man tangled in his own conspiracy about suspended licenses, bar complaints, and a mysterious company called Intoxalot. Both men think they've found a loophole in the system, but what they really find is a reality check. So buckle up, because this courtroom chaos escalates fast, and trust me, you don't want to miss what happens when these defendants go head-to-head with law.
He made that decision. It wasn't me this time. He made this decision. I can't afford an attorney. I need another attorney.
Well, we don't have unlimited attorneys to give you. It sounds like you have issues with the attorneys that get assigned to you. And that began.
That's not my fault.
Well, it sounds like it might be something that's related to you more than the attorneys, since you've now gone through 2 attorneys. So, Mr. James, I don't know how we're going to proceed on this case. We don't have unlimited attorneys that are contracted with this court to assign to you.
That's not my fault.
Well,
If you're going to tell the attorneys that they don't have to help me, then what am I going to do? You told me in open court December the 16th that they don't have to do anything for me.
Go. The sovereign citizen word salad has officially begun. Every time you hear phrases like special appearance, conditional acceptance, or Naturalization Act of 1779, just know that someone has spent way too much time on YouTube law forums. What this man doesn't realize is that none of this pseudo-legal jargon holds any weight in court. Judges have seen it all, and by now, the patience level for this nonsense is near zero. It's almost impressive how confidently wrong he is. But hey, confidence doesn't equal competence, especially in front of Judge Perkins.
Have to do anything for you. So that's just not true. And
what was
you
you
need
referring
to how you
what was you referring to when you said that? When
Well,
you said that my turn is, what was you referring to when I told you that I needed them to get in touch with Intoxilot? These are the people that are holding me in here, bringing false charges against me. Everything they charged me with, I served my punishment on that already. With Intoxilot charges.
Those are two different things, Mr. James. You are charged with driving on a suspended license. The issue is whether or not the Department of Licensing suspended your license, whether you were given notice and due process, and the information pertaining to your status and whether you chose to drive after the fact. Those are the relevant issues. So you may have other concerns. I don't know your situation with Intoxilot. I know you have a beef with them about whether or not they conveyed information to someone. I believe that's what you've said previously.
Well, you guys are their enforcers. Y'all enforcing Intoxilot. I just spoke to DOL. They say they're not going to get involved with what's going on with me in Intoxilot.
That's right.
You can't make Intoxilot give them the compliance.
That is not. That's whether or not you had a valid license on the date of violation is the question.
Well,
I'm not sure if the defendant's trying to represent himself or summon a different dimension. The words are there, just not in any order that makes sense. Judges deal with plenty of pro-SE defendants, but this is another level. It's like watching someone try to outsmart the system with crayons. What's even more wild is that Judge Perkins still keeps his composure, calmly granting him a jury trial while the defendant babbles about privacy and affidavits. That's
data violation. I'm assuming that's what Ms. McDonald has in her file, and that's why she filed charges, and that's why they're proceeding.
Correct.
They told the DOL informed me that they didn't suspend my license. They can't make Intoxilot give them the compliance. And Intoxilot sent me a settlement letter saying if I paid $139, I will receive my license back. I paid $139. They still haven't gave me my license back. So they led me to believe if I pay this amount, they would give me my license back. The amount was paid, and they still have not gave me my license back. Now they're saying it's something else.
No, you're still showing up suspended, Mr. James, as of right now, and there's a reinstatement condition that you have ignition interlock with compliance for at least 4 months. That is a requirement.
The court said I complied. The sentencing court said I complied with the 4 months.
What citizen court? I don't know what you're talking about.
The court that sentenced me in Seattle District Court. Seattle District Court said I complied with my 4 months. They said they was monitoring me at the same time Intoxilot was monitoring me. They both had my car under GPS monitoring me. And the court that sentenced me to the 4 months, they said I complied with my 4 months. They said that they had a tab on me just like Intoxilot did.
Move from the sovereign citizen playbook. They always want private hearings, as if the law bends to their personal comfort. But here's the truth. Public courtrooms are a cornerstone of justice. Transparency prevents corruption, not some secret backroom hearing. The irony is almost poetic. They scream about freedom and constitutional rights, but want to dismantle the very system that protects those rights. Judge Perkins shuts that down with pure professionalism. Case closed, literally. And
They said I'm finished. I talked to the clerk of court. They said they also was GPSing and monitoring my car during the same 4 months Intoxilot was. And they said I completed the 4 months. So if the court was monitoring me at the same time the Intoxilot was monitoring me for 4 months, the court said I completed it. Because if the court otherwise,
what are you talking
otherwise
about?
they would have turned over.
Mr.
Otherwise,
James.
they would have notified
Mr. James,
DOL to suspend my
Mr.
license.
James, what court are you talking about? I think you hear what you want
King
to
County
hear.
District Court. King County District Court, the court that sentenced me on the DUI charge. There is no other court, ma'am. The court that sentenced me on the DUI charge. The court that sentenced me to the 4 months compliance with the DUI. No more than 4 months. It could have been less than 4 months. It was on my car. The court that sentenced me was monitoring my car,
right? The 2015
yes, ma'am.
case, you were sentenced in 2018.
But the court was monitoring me at the same from November to 2021 all the way to March of 2022. The court was monitoring my car as I was driving. The court that sentenced me, they say that's their job to monitor everybody they put on DUI, and they have to have that interlock device. They monitored me for the whole 4 months. The judge said I'm finished. I successfully completed it. And he said case was effectively immediately closed. Who opened it back up? Your guess was Intoxilot.
Now we head to Lake Forest Park, but don't relax just yet. This next defendant, Henry James, might just outdo our sovereign citizen from Michigan. He's about to lose his attorney, file bar complaints, and then somehow blame everyone else, the court, the state, and even Intoxilot, for his suspended license. It's part courtroom drama, part personal meltdown, and 100% avoidable if he'd just listened to reason. Let's watch how fast this...
The whole 4 months I had the thing in my car. That was the court that sentenced me. That's Seattle District Court, the West Division. I talked to the clerk of court. They said he monitored the whole 4 months it was in my car. They said, and they sent me an order saying I successfully completed the 4 months. And that this case is closed. So if the court is saying I'm finished, and Intoxilot is saying I'm not finished, we have to go on what the sentencing court is saying. I'm going on what the sentencing court is saying.
Well, then you are doing that to your detriment. So if you choose not to listen to your attorneys, you are still showing suspended. Your status is suspended.
My attorney haven't told me anything. My attorney is not even talking to me. He won't even get in touch with me. He haven't told me anything. One attorney said, Sean Parent said, I need to put it back in my car 11 more months. It was already in my car 14 months. And you keep saying I have to put it in there for 4 months. The machine was in my car for 14 total months until they was ordered to take it out of there. Had I would have taken it out, a warrant would have been placed for my arrest. I didn't take it out. The people who put it in my car took it out.
There could be two different things going on. The court may have ordered you to have an ignition interlock device as a condition of your release while the case was pending. If you entered a guilty plea to the DUI or were found guilty, then the Department of Licensing will impose certain restrictions based upon your plea. And that may be what's going on.
I did everything. I took the classes. I took the DUI classes. I paid all of
and I think your
victim fund. I did everything, all that. I did all that already.
Okay. If you would stop talking, I think your DUI case is closed, but you still have obligations to the Department of Licensing. They have their own systems in place. And
they told me I don't. They told me I don't. In a recent email that I got from them 2 weeks ago, they said they have nothing to do with this. They don't want to. They say this. Everything that's going on, DOL told me, is between me and Intoxilot. They say I broke the conditions of Intoxilot, not DOL. They say that Intoxilot saying I broke the condition.
So, Mr. James, it appears to me that Intoxilot is not going to show that you're in compliance for whatever reason, and that is your beef with Intoxilot. Okay? But if Intoxilot is not sending the proof to the court or to DOL, it's not the court, it's to DOL, then they're not going to lift the restriction. They're not going to show that.
I understand that, but it's DOL is not holding my DOL is have to go by what Intoxilot said.
Right.
And everything you saying,
DOL does not
proof.
DOL apparently does not have proof that you have the 4 months compliance.
Well, I told them they can contact the sentencing court. The sentencing
You know it's going downhill when a defendant files a bar complaint against his own lawyer and then expects that same lawyer to defend him passionately in court. That's like setting your house on fire and asking the firefighters why they're taking so long. Judges hate this dynamic because it instantly destroys trust and strategy. The lawyer can't effectively represent someone who's simultaneously accusing them of misconduct. And when Henry insists it's not his fault, the judge subtly reminds him, maybe the problem isn't every lawyer you've ever had. This is one of the most misunderstood parts of the justice system. Yes, defendants have a Sixth Amendment right to counsel, but that doesn't mean they get to micromanage or overrule that counsel. It's a right to representation, not command. The judge